All right, and we're live here. Hello, everyone. Welcome to Legal Lunch and Learn, a weekly live show where we ask our expert your questions on a legal topic. My name is Cindy. I am a staff attorney here at Maryland Legal Aid. My co-host is the director of Community Lawyering Initiative, Attorney Megan McDermott.
Hi, Cindy.
And joining us today is our senior attorney of training and an expert on expungement law, Attorney Todd Cagwin.
How's it going?
And of course, working behind the scenes so everything goes seamlessly is our production engineer, Alec Chase. So today's topic is going to be expungement. So if you have questions about expungements, please make sure you put them in the comment down below and we will get to them at a later part of the show. If you want to remain anonymous, you can also direct message or private message us and we will make sure that those questions get to us. And of course, if you do have an immediate civil legal issue, you should be contacting us. And of course, Alex will be putting that information for you in the comments down below. So I'm going to go ahead and read them for you if you need it. Our email is lawyers@mdlab.org. That's LAWYER at mdlab.org. Our phone number is 443-451-2805. So of course, at the beginning of every video, I do have this disclaimer. If you just because you are watching our video and you're learning something about expungement law, it does not establish an attorney-client relationship between you and any of the attorney participants or with Maryland Legal Aid. And of course, for those who do need captions, please go ahead and go to YouTube. After this live event, we will upload those for you, and Alec will upload the link for you in the comments down below. All right, with all of that out of the way, let's talk to our expungement expert. Hello, Todd. How are you?
I'm well. How are you, Cindy?
I'm pretty good. So just to begin, can you tell us about your expertise in expungement law?
Certainly. So I've been with the Community Lawyering Initiative that you just mentioned for a little over 2 years now. And the main goal of the initiative is to try and reduce barriers to housing and employment through the process of expunging criminal records. So I'd say right now I probably have a caseload of anywhere between 120 and 130 expungement clients. I know that the unit as a whole in 2019 assisted just under 2,000 clients, and as Maryland Legal Aid as an organization for 2019 filed over 14,000 petitions, so it's quite a large number. I probably am in court for expungements 1 to 2 times a month on average, I think. So it's a pretty big caseload, and we do quite a few expungements.
And that's pre-COVID, is that correct?
Correct. Yeah, that's mainly those are 2019 numbers.
Yeah. How has COVID changed our practices here in terms of expungements?
So we're still doing them like we were prior to COVID. I'd say the biggest hurdle has been trying to figure out how to get our services out to the community. One of the big things of the Community Lawyering Initiative was, we took our services out into the communities where it was needed. So we probably did, on average, 28 to 30 clinics a month at various locations throughout the Baltimore City and the state of Maryland. That's obviously changed through COVID. So a lot of it has been trying to get our services out there through means like this, virtual presentations and whatnot. So, it's certainly been picking up. The courts have opened back up, so we're now seeing expungement hearings start happening in the courts. So it slowed off a little bit once the pandemic started, but it's starting to really pick up again.
Oh, thank you very much for that. And I just want to mention, so expungement law is something that we here at Maryland Legal Aid do day in and day out. So if you are a person with a case in Maryland and you're thinking of applying for expungement, you should contact us, and you do have our information. So we're still doing that. Give us a call or email us and we'll try to handle that for you. So with that, out of the way, let's just dive into what expungement is all about. So let's just start out with what exactly is expungement? What does it mean?
Certainly. So expungement is basically trying to clear up your criminal record. Basically, from the minute that somebody gets arrested, there is some sort of record. And even if that arrest doesn't result in that person appearing in court, there still is a record. Now, when they get to court, there's another record. If they were incarcerated in between the arrest and court, there's a record of that. So there's multiple levels of records being created. And so expungement is basically trying to clear up all of those records from somebody's background. The biggest thing is that it deals with criminal records, so it doesn't deal with civil cases, and it doesn't deal with some driving citations. So there's a difference between certain traffic citations or tickets that you might get. Some carry a jail sentence, some don't, and the ones that carry a jail sentence are what are covered under expungement law. So short answer is expungement is clearing up your criminal record.
So let's be a little bit more specific. So what does it exactly mean by clearing? You know, are the documents still floating around somewhere? Does it clear your record at a federal level? Are there any limitations?
Certainly. So basically, by clearing up your record, it means that the court will take their file and essentially shred it. It's gone. There can't be any record of it whatsoever. And when the expungement is granted, the court will also issue that order granting the expungement to the various agencies throughout the state. And when I say state, I mean Maryland, because we're dealing with just Maryland cases. So the court issues the order. It might go to the police station, the state police, the city police, sheriff's office, whatever agency had a part in that specific case will get this order, and they have to destroy all of their records. There's no longer a record of it. So when the expungement is granted, it takes care of all of those records dealing with that particular case. The limitation is basically it's just with Maryland criminal cases. So if there's a federal case, then that will still be there. If there's some sort of federal record, that will still be there. It might still pull up on some sort of third-party background check. I can't think of an example of what that might be right now. The other semi-limitation is with the advancement of technology over the years. There might be some sort of website out there that has pulled information from another website or a database or some other public record that is still showing up. However, the actual case, again, that the police department has, that the court has, that some sort of incarceration facility has, those records are gone completely. And when they're expunged, they are trashed.
All right. So just now that we talked about the limitations of expungement, why would someone still want a record to be expunged, knowing that, you know, it might not be 100% off of the public records?
So there are a lot of negative implications that come with having a record. So, you know, it can affect your job applications, it can affect housing situations, public benefit eligibility, professional licensing. So there are a lot of ramifications with having a public record or a criminal record. And I want to kind of clarify that is that when I say criminal record, it doesn't just mean that you were found guilty of something. That could mean that you had a case that went to court and that case was dismissed. You were found not guilty. Maybe it was null pros, meaning the state wasn't willing to prosecute. In Maryland, it could have been placed on the STET docket, which is an inactive docket that's there for 3 years. Even though you weren't found guilty, those are all dispositions that are not convictions. They're still showing up and they're still on your criminal record. And you might have employers, you might have landlords that are looking at this and doing a background check. They might not know what that stuff means. They just see that something is coming up on your record, and that could prohibit you from getting a job, from moving forward in the job application process. It could hinder you from getting housing. So there are some very negative ramifications that come with having a record and not just a record with convictions.
So I think I do see this with a lot of my own clients, and of course, I think people do want to know the answer to this question too. So after you go through expungement, either on your own or you know contact us and we did it for you, can an employer still use and for whatever reason the employer finds the record that's supposedly already being expunged, can the employer use that as a reason to not hire you?
So no, it's actually illegal for an employer to use an expunged case as a reason for not hiring you. So that's a very important question. Yeah.
Yep. So I think that also goes into why it's so important to officially get something expunged, so that you do have that added level of protection.
Yeah, it's just, it's knowing that it's off your record and knowing that it can't be used against you. Once you have that order from the court, that's the paper saying that this record is completely gone, and it shouldn't be coming back really to haunt you in any way. So employers can't use it. Housing shouldn't be able to use it. So it's a big relief once you have that expungement order.
Right. And of course, make sure you keep the copies of the order.
Yes, I tell clients that those orders are worth their weight in gold, so don't lose them.
Absolutely. So now that we're talking about orders and going to court, let's just talk about the procedures of getting an expungement in Maryland. So first of all, how would a person know what kind of record that they have? Because a lot of times, you might have a police encounter, but you never go to court, or you go to court and it's dismissed. So how do I know what I have right now?
Certainly. So the easiest way is probably going on to Maryland Case Search. The Maryland Judiciary Case Search is a public database that is for Maryland records, and you can just type your name in. You can search by county, by party to a case, but that's probably the easiest way, and you can see what might be on your record. And there might be stuff that, as you mentioned, maybe there was an arrest or a case that you never went to court for, but there might still have been an actual court hearing that you didn't have to be in court for. That could still be showing up. So it's important just to take a look there. The other thing to keep in mind with case search is that it's not perfect. It does get updated. It's not necessarily up to the minute. So if there was a court hearing and there was a disposition entered, that disposition might not show up on case search for a certain amount of time. So just keep that in mind. There are some limitations with it. Names might be misspelled. So if you have a common name, there might be a lot of John Smiths in Maryland. So it might take a little bit of work to find out what is on your record. Your contact information associated with that case might be incorrect. Your address might have changed, which is another kind of side point, is that if you have any cases with the courts, it's important that if you've moved, you let the courts know that you have moved. Otherwise, you might not be getting very important notices from the court, because they get mailed to the address that the court has. They don't get forwarded to the mail. So that's a very important thing. Another place to check is the central repository here in Maryland. The downside with that is it's not free. The upside is that it is very accurate, because they take a fingerprint and they associate everything on your record associated with that fingerprint and give you a printout. I think the fee for that to go to the CJIS is maybe like $40. So easiest way is to check on Maryland Case Search, enter your name in and see what pops up.
Yeah, absolutely. So now that, you went through case search and you see a bunch of case, and I think the most common question we get next is what can be expunged? What is eligible for expungement, as we lawyers say it?
Certainly. So the biggest thing with expungements is that the Maryland statutes regarding expungements deal with really what the disposition of the case is, not necessarily, when it was. It could have been 30 years ago. That doesn't mean that it's coming off. It's important to note that there's nothing that is automatically expunged in Maryland. So if something is on your record and you don't do anything about it, it's going to remain on your record. But basically, any essentially non-conviction is going to be expungible. If it was null pros, if it was dismissed, if it was a not guilty acquittal, those are all expungible. Stets are expungible. Probation before judgments are expungible. And then there's certain convictions. So there's an enumerated list of misdemeanors that with a conviction are eligible after a certain amount of time. It's 10 years right now. And then there's a very finite list, 3 felonies on a conviction that are eligible after 15 years. So it's not, cut and dry and it's a simple answer. This is expungable, not expungable. It depends on the disposition. And then with some of those dispositions, it depends on a waiting period. And in that waiting period, if there were any other convictions in that waiting period, that might either continue the waiting period or it might prevent stuff from being expunged.
All right. So earlier, I think you mentioned there are felonies that are now maybe eligible for expungement after a 15-year waiting period. And I think that's a very short list. Do you mind just reading off what those felonies are?
Certainly. So the first one is felony theft. The second one is possession with intent to distribute. And that's something to keep note of because it's not possession with intent to distribute, dispense, manufacture. It's simply possession with intent to distribute. And the third one is felony burglary. So it's burglary in the first degree, second degree, or third degree. Fourth degree is unfortunately not included because one, it's not a felony, and it wasn't included with the eligible misdemeanors. So that's kind of an odd carve out that was not included as a potentially eligible conviction. But felony theft, possession with intent to distribute, and burglary first through third degrees are eligible after 15 years.
All right. So are there, and we all know whenever you have a rule, there's always special things or exceptions to the rule. So talk about some of the common special exceptions to the rules that we just talked about.
Certainly. So two of the big ones, one is what deals with the marijuana possession conviction. So whereas most convictions require a waiting period, and it's at least 10 years for the eligible misdemeanors. Possession of marijuana in any amount is just a 4-year waiting period if you've been convicted, and it doesn't matter if you have other convictions in that waiting period. So if there's a possession of marijuana conviction and it's been 4 years, file for expungement and get it off. It should be coming off. The other one that we see a lot is charges dealing with DUI or DWI. The biggest thing with that is if there is a probation before judgment with a DUI or DWI, that is not eligible for expungement. So I'd mentioned before that probation before judgment typically is eligible. This is the one instance where it's not eligible for expungement. So if there's a conviction or a probation before judgment for a DWI or DUI, unfortunately, that is not eligible for expungement.
All right. So I think another concept that might be harder to grasp is what we lawyers call the unit rule. I think it's when, anytime you get arrested and you get charged with something, you're getting charged with a gazillion other things. And explain to us what happens in terms of, all the other charges that were dropped in order for you to plead guilty on one. What happens then and what is eligible?
Certainly. So the unit rule deals with any charge or charges or cases that are associated with each other. So you had mentioned where you get arrested and then you all of a sudden you have a bunch of charges. Well, similar thing happens if you get pulled over and you get a traffic citation. Most times it's not just one traffic citation, there are multiples. Well, all of those charges within the same case or all of those traffic citations from that traffic stop, they're all a part of the same, we call it the unit. And so how I explain it, I think is easiest is if there is one bad apple in that unit, then all the apples are bad. So if you have a case in, let's say, district court, and there are 4 charges in that one case, and 3 of the charges were dismissed, and that's an eligible disposition for expungement. However, one of those charges was a conviction that is not eligible for expungement at all. Well, that entire case is not eligible for expungement. Even though 3 out of those 4 charges would be eligible for expungement, that 4th charge is not eligible, and therefore the entire case is not eligible. This also applies with, let's say that same case with those 4 charges was sent up to circuit court, and circuit court split it up into 2 separate cases with 2 charges each. Well, if one of those 2 cases is eligible for expungement, but the other one is not, neither of those 2 cases are eligible for expungement. Switching over to traffic, if there's a traffic stop with 10 separate traffic citations, and on case search it shows up as 10 separate traffic citations, none of those potentially, if they're sent to circuit court and all grouped together, will be eligible if one of them is not eligible. The other kind of nuance with traffic is in those 10 separate citations, some might be incarcerable, some might be non-incarcerable. And the non-incarcerables aren't eligible for expungement at all. The incarcerables would be. And so as those 10 separate citations, if 5 are incarcerable and one of those 5 is a conviction and not eligible for expungement, then those related traffic citations are not eligible for expungement either.
Whew.
So it's a lot.
It is a lot. So, dear viewers out there, if you are a little confused, that's absolutely normal. I just want to take this opportunity to emphasize that Maryland Legal Aid does do these for you for free if you are eligible for our services. So once again, we do have our contact info in the comment section. So make sure you contact us if you want an attorney to take care of these for you for free. So for those who want to do it for themselves, of course, what if you're still going to court for something? Can you still apply for expungement?
So yeah, so the biggest thing is that in order to apply, file a petition for expungement of your records, is you can't have any pending criminal cases. So if you are awaiting trial for something right now, then you won't be able to file for expungement for anything until that pending case is closed out, until there's a final disposition in that case. Once that happens, and it could be even that day, maybe you have a court date tomorrow, August 26th, and you have court at 9 o'clock, and at 9 o'clock, that case gets dismissed, and the final disposition is a dismissal. You can walk out of the courtroom at, say, 9:30, go down to the clerk's office and file for expungement.
So if I am still going to court, but for, probation only, can I still apply, or is that only if I have a open case where my guilt or innocence has not been determined yet?
Yep, so that's a great question. So active probation is not considered an active case. So it's really just pending criminal charges. If you have a charge, you have a court date coming up for that charge, that would be an active case. If you're on probation, there has been a final disposition in that case, and you are currently serving probation, that is not a barrier to filing for expungement.
All right. So for those of viewers out there who want to try to file it for themselves, where do they even go? And what is let's do one thing at a time. Where do they go to apply for expungement?
Certainly. So you're going to go to the court. You're going to file in the court where the disposition occurred. So if the case started in district court and ended in district court, then you would file in district court. If the case went from district court to circuit court, then you would file in circuit court. And in the circuit court granting the expungement and issuing the order, one of those orders would be sent to the district court of that county, where they would instruct that district court to expunge any record that district court has for that case. So you're going to file in the court where the disposition happened. Now, depending on which court you're in, that will really determine if there's a filing fee. In district court, you can file for free as long as it is essentially a non-conviction case, again, with the exception of the marijuana possession. If you are filing for a conviction in district court, it's a $30 fee. In circuit court, there is a $30 fee no matter which petition you're filing. So there are two petitions. I don't want to get too confusing. There are two petitions, an A form and a B form. No matter what form you're filing in circuit court, there is a filing fee. In district court, if you're filing on the A form, it's free.
Yep. And for those who want to do it themselves, I think the clerks of the court do have copies of those forms for you to fill out. And I think they do have those online. If you search for it online, you can print them out and fill them out. So after, you fill it out, you go to court and file it. And just to be clear, it's $30 per petition for those that do cost money. So it's not per filing, it's per petition that you do file. So after you go ahead and file your petition in court, what happens next? Do you have to go to a hearing then?
So hopefully you don't have to go to a hearing. Sometimes you will though. If you file a petition for expungement, once you file it, the court will serve it on the state's attorney. The state's attorney then has 30 days to object to it. If they feel like this case should not be expunged, they will file an objection. And there should only be a hearing if the state files an objection. If an objection is filed, you will get notice of that and what the objection is for, and then the court will issue a hearing date. And if you get a court notice with a hearing date, you have to show up. You should always show up if you have a hearing notice to court. So there is a chance that you might have to appear for a hearing on the expungement petition. So that's really the main thing that could happen once you file. So just keep a lookout. And again, that goes back to if you've changed your address since you filed, let the court know, because otherwise you're not going to get that notice. And you might hear that, you might miss that hearing date. And if you miss it, what should be expunged could be denied and still stay on your record. So it's very important that you let the courts know if you move what your new address is.
Absolutely. And just generally, once I file a petition, how long does it take before something comes off of my record?
So unfortunately, it's not a quick process. I mentioned before, once you file, the courts will serve it on the state. They have 30 days to object. So there's automatically a 1 month waiting period right there. Depending on the county within the state, on average, I would say it's 8 months to a year, probably, before you have that order in hand. So from the date that you file, 8 to 12 months later, that's typically when you'll have that order in hand. So it's not a quick process, but definitely worthwhile getting it started and getting that order ultimately from the court.
Yeah, absolutely. And of course, with COVID and the courts being shut down for a while, the process is probably taking even longer.
Yeah, so the courts were shut down for a time, and even if courts did have personnel there, they were in a very limited capacity. So yes, there was stuff with courts were kind of postponed. If you did have a expungement hearing within that time period since March, again, keep a lookout in the mail. You're probably going to get a new hearing notice. If you've moved, let the courts know. If you're unsure, call the clerk's office and give them your name. Let them know this is the case number. I had a hearing. I don't know what's going on. The clerk should be able to let you know if a new hearing has been scheduled and if notice went out. And if notice did go out, you didn't get it. It's a good opportunity to have it resent or to let the court know that you changed your address and update the court with your new address.
Yep. So that's all the questions I have prior to starting this Facebook Live. Now let's move to some questions from the audience, and we'll go ahead and bring Megan back for that part.
Okay.
Cindy. Hi, Todd.
Hi, Megan.
So one question someone has is they had a friend. These two people have the same type of charge. They both have a guilty misdemeanor theft charge, and it's been over 10 years. And the person who is asking the question was saying their friend told them they were able to get their item expunged. But the person asking the question is saying that they were told by an attorney they can't get it expunged. So is there ever a time where someone would have the exact same charge as somebody else? One person could get it expunged and one person couldn't.
There is. That's a great question. So the thing with a misdemeanor where there's a conviction is there's a 10-year waiting period. So you have to wait 10 years in order to file for expungement. And it's not just 10 years from when the disposition was entered. It's the 10 years after either the disposition or the completion of any sentence or probation. So it could be that one of those two cases, maybe there was a suspended sentence and the disposition date 10 years from that date has already run. And the other case, there could still be a few years on that 10-year clock running out. Another situation could be is that if one of those cases in that 10-year period, there was a subsequent conviction, that occurred and that subsequent conviction is not eligible for expungement, that could be a barrier from getting that misdemeanor theft conviction expunged, whereas the other case did not have a subsequent conviction, and therefore the 10-year clock expired and they're eligible to get that expunged.
So it sounds like there's not always a cut and dry answer for what can be expunged and what can't be.
Unfortunately, in the expungement world, it's not as cut and dry as I'm sure everybody wishes it was. So yeah, it's very dependent on, again, what the disposition was, and then in certain cases, what happened in a time period after that disposition or sentence.
Okay. So you and Cindy talked a little bit about active cases, and an active criminal case can prevent someone from getting an expungement. Now, what about diversion courts? So this individual was put into a drug court program and they have to go back to court every month. So their case is showing up as active, but they already received a disposition on their case. What does that mean for expungement?
So it's a great question. So that would not stop us from filing expungement. There are some courts that look at like a drug court, for example, is a diversion court program. As some courts look at that as an active pending case. A disposition has been entered, and basically once that disposition is entered, the statutes state, and there's case law to support it, that it's that case is no longer active. So even if the diversion case is showing up as active, as long as there has been a final disposition in that case, we should be filing for expungement. It would not be an active case and stop the expungement process.
Okay, great, thank you. And then a little bit more about probation before judgments, or PBJs. So when people get a PBJ, sometimes they get a probation period. So this person was serving, had to do probation for a year. They had to do community service and fulfill some other requirements. And they want to know why they're a year out from their court date. They finished their probation successfully. Why can't they file for expungement now? And is there ever a time where they could file for expungement, considering they completed their probation successfully and this was their first offense?
Certainly. So the probation before judgment part of the expungement statutes are a little confusing. And if you read the statute and then read the form that you file for expungement, it's not very cut and dry. Again, nothing's really cut and dry with the expungement world. So with probation before judgments, there is a 3-year waiting period essentially. And the only exception to that is if the probationary period is longer than 3 years, in which case you'd have to wait until the probation was over. So in this case, if there is a 1-year probationary period and probation was successfully completed, in order to file under normal course of expungement process, you would have to wait for 2 more years after that probationary period ends. However, there are certain situations for a probation before judgment disposition, and also for a STET disposition, because the STET requires 3 years flat, where you might be able to file before that 3-year period. And it's called, per the statute, filing for a good cause exception. And if the court finds good cause, they may grant that expungement prior to that 3 years expiring. So we don't see this that often. It's tough because it depends on a lot of different factors. If this person has a probation before judgment, they had a 1-year probationary period, they completed probation successfully, there's nothing else on their record. This was the only case on the record, the only blimp on the radar. And not only during probation, but say maybe after probation, there's been a lot of maybe community involvement. They're working. We try and look at all the positive factors that have gone into the situation to try and right the wrong that happened. We might consider filing for a good cause. And again, if the court finds that there is good cause to grant the expungement and grant it early, then there is a possibility that that probation before judgment could be expunged after only 1 year, whereas it would originally have to wait 3 years.
Okay, so you said that the court would grant it. Does that mean for good cause, the individual would have to go to a court hearing?
Yes. So what would happen is you would file the expungement, and your grounds for filing for expungement would be that this is a PBJ, probation before a judgment, disposition. The state would object because you're essentially filing it too soon. You filed it after 1 year in this example, and it's supposed to wait 3 years. And at the hearing, once the objection was filed by the state, the court would set it in for a hearing, and you would have to go to court for that hearing, and you would request the court grant this on a good cause exception. And in support of that, you would really try and state everything I just went over, which is you completed probation successfully, you've been doing all this other stuff in this time period, volunteering, community work, working, full-time, part-time, but you've been holding jobs, and you would show the court why they should grant this good cause exception early.
Okay. So sticking with this idea of good cause, we talked about getting a good cause for a probation before judgment or a STET. What if I'm 5 years into my period after a guilty? Can I file a good cause exception on a guilty case?
So unfortunately, no. The good cause exception only relates to this non-conviction disposition. So it could be, basically it applies to the STET and PBJ dispositions. Unfortunately, with a conviction for a misdemeanor or a felony, there is no early filing exception. You have to wait that 10 years for eligible misdemeanors and 15 years for the eligible felonies.
Okay. And then sort of one final question. Sometimes we have clients that come in to legal aid and they don't have anything on their criminal record, but they feel embarrassed about maybe old bankruptcy cases or old financial judgments. Maybe there was a protective order from several years ago. Is there any way to get those types of cases expunged?
So expunged, no. Expungement only deals with criminal matters, criminal and traffic matters. However, there might be cases or situations where certain cases could be shielded. And it's important to note that shielding is not the same as expunging. While expunging destroys the record at the courthouse or the police department, shielding simply takes it off of the public viewing. So shielding would take it off of case search, but it doesn't clear the record completely, absolve the record, it's gone and destroyed. Now, shielding only applies to certain things as well. So, maybe there's a domestic violence case on somebody's record, or a bankruptcy or judgments. Those would stay on, unfortunately. Protective orders of peace orders, sometimes those can be shielded depending on what the outcome of those were. Certain convictions for more minor crimes can also be shielded. And there's a specific list, I think there might be 12 of them that are eligible for shielding. But unfortunately, expunging only deals with criminal records. If there are other civil matters, bankruptcies, judgments on your record, those are not eligible to be cleared off through the expungement process.
Okay. And as far as shielding versus expungement, is one better than the other? How are they different?
Well, the main reason that they're different is they kind of handle different things for the most part. Expunging will clear off record. It destroys everything off your record that's eligible for expungement. So there is no longer a record anywhere of that case that has been expunged. With shielding, it just will take it off of the public viewing. So I can't go on case search and see something that was shielded. It doesn't mean that there's not a record of it, though. So that's an important distinction, is that with shielding, there still is a record of it at the courthouse, for example. However, I would not be able to look up somebody's name on case search and see a case that has been shielded.
Okay. Thanks, Todd. We're going to bring Cindy back now to wrap up with a few final thoughts.
Alrighty, so now we're at the end of our show, and this is one of my favorite things to do. So for our fellow Marylanders out there, what is the most important thing you would like our audiences to know about expungements?
Take advantage of it. If you have stuff that can be expunged, do it, because there are some very significant negative ramifications that can come from having stuff on your record. Don't just assume that because it was 15 years ago that it's no longer there. Certain background checks might only go back a certain amount of time, others go back forever. So if you have stuff on your record that is eligible for expungement, file for it, get it expunged. If you're unsure, check on case search, call legal aid, email lawyer@mdlab.org, call us at 443-451-2805. Even if we aren't able to take you on as a client, we might still be able to just do a quick check and say, there is stuff that's eligible for expungement, here's what it is, and here's how you go file it. So if you have stuff that can be expunged, expunge it. Please file for it, get it expunged, get it off your record. Then you don't have to worry about it. It's gone. It won't affect you down the road.
Yep, absolutely. That's exactly how I feel too. Thank you so much for joining us today. So before we end the show, though, we do have some questions that we received last week after we have ended the live portion. So I did talk with our housing expert, and I do have answer for you. So the first question is, what is an illegal notice? I know we're changing topic here. What is an illegal notice for evictions from the landlord? Before COVID, there is no requirement for a landlord to tell you before they file for eviction. They can go to court to file it, and your notice will be the one that's from the court. During COVID, however, if you're covered under the CARES Act, then the landlord needs to give you a 30-day notice before they can file for eviction in court. So if you do feel, or if you want to know if your landlord is doing something illegally, please contact us. We are here to help you. And of course, in terms of illegal notices, those are so different on a case-by-case basis. So make sure that you're contacting us and you're speaking with an attorney. And of course, there was another question about what if there's a severe health concern in the apartment that the landlord is not taking care of. If that's the case, contact us immediately. So this is, of course, a case-by-case kind of thing, and you need to talk to an attorney to see what your next step is immediately. So with that said, thank you everyone for joining us today. Next week, we will be talking with Maryland Legal Aid's foreclosure and bankruptcy expert, William Steinwindow, to answer your questions about mortgage forbearance and other stimulus relief. So if you do have a question about mortgage forbearance during COVID and other stimulus relief, leave a comment down below or email us or private message us your questions, and we'll be happy to answer those for you. And of course, if you found this video particularly helpful, go ahead and share this video and make sure you tune in next Tuesday at noon. Thank you so much and have a good rest of the week.